Would you like to make an opening statement, Mr. Lind?
Thank you, Mr. Chairman. Yes. First of all, thank you for the invitation to present to the committee. I won't go over the matters I raised in our written submission, but I would like to speak to a couple of other matters.
Yes. Please do so.
There's a key question that seems to be raised by a number of the submissions this morning as to who is the umpire, who is the one who decides who's in and who's out. Is it the Parliament? Is it the courts? Is it the regulator? Is it the administrator? All of these bodies have a role to play. Key question in deciding who's in and who's out in this context is who's relieved from paying tax, who's relieved from the tax burden that the rest of us have to bear. The sustainable underpinning to answer that question, it seems to me, is that tax relief is granted to activity that is of that delivers such common good outcomes that it may otherwise have to be paid for by the government directly. So I often say to my charitable clients, if you're delivering something that is of worth and public good, that if you didn't do it, the government would otherwise have to do, you're probably centre of the pocket in terms of what charitable means. Who decides? Who answers that question? Who's the umpire? Now, the amending legislation, the bill before us, shifts the pendulum to the government, to the Parliament and the regulator, away from the courts. And that's okay. But do we then have an independent umpire? The courts have, of course, taken over 400 years to develop their understanding of charity. And my concern about a public benefit codified test, the reduction of that 400 years of law into a codified test, I think needs a lot more consultation than the consultation that this committee has undertaken to get to a public benefit bill. I also want to make some comments on the need for an unconflicted administrator. In my view, the ATO, as the current administrator of who's in and who's out in terms of endorsements, is severely conflicted. This is the arm of government that is responsible to maximise the size of the public purse. And it's the arm of government that currently stands at the gateway to determine who gets the benefit of tax relief and who doesn't. An independent umpire is needed, a Charities Commission. We've just heard from the New Zealand Charities Commission. I understand you'll be hearing later today from the UK Charities Commission. Commend that. Commend their experience to your consideration. I support the need for an independent Charities Commission in Australia who can, without fear or favour, make decisions about who's in and who's out in a tax-exempt regime. And it makes sense that if such an independent umpire is to be established, a Charities Commission, resourced, staffed by very expensive brains who will need to drive that organisation, that the established organisation have input into the rules that they will administer. So my concern for this sector is that it often runs on the smell of an oily rag, or at least a lot of the organisations that are involved in it do. They want to spend their income, by and large, on their purposes, on their noble charitable purposes. They don't want to spend a lot of money paying consultants like me. My concern is let's give them a voice by establishing an independent commission who can, with them, craft what charity means in our modern day Australian context. Now, a lot of that work's already been done through the 2000 Charities Definition Inquiry, through the Productivity Commission report. A lot of that background work's been done. I'm not suggesting that has to be done again. That can be leveraged off. So I'm not against moving to codify the common law, but I have grave fears for the attempt to do it at the speed at which this current bill is being introduced. The first priority I submit is the establishment of a Charities Commission that can aid in the development of a well-considered codified definition of charity for the Australian context. I want to suggest that there's another way at seeking to deal with organisations who public policy may have some real concerns about whether they should be entitled to their tax endorsements or otherwise. But the Parliament, I suggest, is at liberty, subject to its constitutional powers, to specifically include or exclude persons or institutions from accessing particular taxation benefits. Parliament has already extended the breadth of charitable entitlement through the Extension of Charitable Purposes Act 2004 to specifically clarify the ground rules for example, participants in the first 2 years of the National Rental Affordability Scheme, and, for example, for not-for-profit childcare providers, because there was significant public policy reasons to do so. Does freedom of religion mean freedom from tax? Do the words in Section 116 of the Constitution, free exercise of any religion, mean freedom from income and other taxes? It's strongly arguable in my view that freedom of religion does not mean freedom from tax. That there's a freedom of association, a freedom to pursue whatever belief system you may want to pursue as long as it operates within the law, but that does not, it seems to me, necessarily mean that that organisation should be exempt from tax. It can still be free to operate, but it may be a taxpayer. If there are public policy concerns about a particular organisation, the government, I suggest, could move to enact a piece of legislation called something like Exclusion of Charitable Purpose Act, to carve off and exclude particular classes of organisation, or indeed named organisations, from having the benefit of accessing tax concessions. Quite simply, that's not an attack on their freedom to operate, in my submission, but a removal of a public purse subsidy for their operations. Such a move, of course, would require a process, would require opportunity to be heard, would require reasonable time for transition against any such class of organisations or named organisation that was included. Does that mean that the Parliament would be moving to determine what religion means? No, I don't think so. Simply allowing the Parliament to determine who should be entitled to tax relief and who ought not to be. So I commend the consideration of a carve-out exclusion of charitable purpose mechanism, in addition to the extension of charitable purposes mechanism that already exists. Just wanted to make one other introductory comment, and that is that the current bill that's before us seeks to amend items 1.2 and 1.1 and 1.2 of Section 50-5 of the Income Tax Assessment Act 1997. 1.1 being charitable institutions and 1.2 being religious institutions. Within 1.1, of course, there are we have the 4 heads of charity that have been discussed at length this morning, in which religious institutions can be included. 1.2 does not have a similar charitable test. So it allows the endorsement as tax exempt of religious institutions that do not have charitable purpose. I think that's a key distinction. Therefore, perhaps the reform is needed more in relation to 1.2 than it is to 1.1. Because 1.1 charitable institutions already are subject to a test of having to be charitable, which implicitly in our system requires a public benefit analysis. That is, it has to be a public body that does have charitable purposes which by definition have to deliver public benefit. So religious institutions under 1.2 are currently not required to be charitable.
Well, I think, Mr. Lind, we should finish there because we are a bit behind time. So we'll let the senators ask questions, beginning with Senator Cameron.
Yeah.